Welcome back to the Unredacted Truth, where we fill in the missing gaps in the world's largest scandals and mysteries. In a world of rumors and theories, my job is simple: uncovering the truth underneath the glitter and the grime. We are exposing a pattern: protection, power, predators, structures built not on justice, but on silence, fear, and impunity. We're not talking theory, we're talking court records, stamps, dates, testimony, and a system that, to this day, continues to fail the public and protect the predators among us. Let's get to it.
Hi, it's Sunday. Good morning, good afternoon, good night, good evening. Did you hear? The DOJ gave us another document dump, millions and millions and millions of files as the mainstream news media, BBC, CNN, CBC, everyone's been reporting. And I am curiously excited to go through the most recent DOJ dump with you guys, which is why we're having a slight pivot with today's video, because I couldn't wait to go through the documents for you, with you, whatever, for us to go through these documents together. But don't worry, we are going back to reading the police case notes and following Detective Joe along with his investigation, his 2005 investigation on Jeffrey Epstein and co-conspirators. But don't worry, Monday we are back to the police case notes. Hi, I'm Sonia, and welcome to the Unredacted Truth, where I've been going through official police documents, case notes, files, papers, and all that is available in the Epson investigation to provide you with the true facts, villains, victims, and truth of the crimes. So, if you haven't had a chance yet, I highly recommend that you head over to the Unredacted podcast, where you can follow up and catch up by starting with the Let's Read the Epstein Files investigation, so you too know exactly what's going on with Detective Joe and are able to follow us chronologically to follow the breadcrumbs all the way to the mess that is today. We have a whole bunch of other Epstein videos as well. Find out what truly happened in the words of Virginia Giuffre from her unreleased memoir that was submitted in the police case files and notes, among the many, many civil suits, lawsuits, and everything else, where we will be able to go through and figure out the true names and what actually happened, to naming names and giving the victims their stories back. Currently, like I mentioned above, we are going through the Palm Beach police investigation notes from the start in 2005, because that is what led us to where we are today. As you can tell and see, I am a new channel trying to grow. 2005 and in 2006, 26, it's a lot harder for an individual and a channel. But I'm the little engine that can, and I am determined to get all the facts out, the unredacted truth of what has been concealed behind and among the Epstein files for decades, even if it means that I'm fighting an uphill battle against the sensationalism, propaganda, political rhetoric, marketing dollars, and everything that goes into the Epstein case and the cover-up. So today I ask you to please help me continue the fight and get the truth out. The easiest way is to hit that subscribe button and share your thoughts in the comments. Together we can start an honest conversation. At the conclusion of reading the police notes, we shall pivot to the 2000th century transcript, which set the stage for the political theater and drama we're seeing today. And trust me, you don't want to miss that. From there, we will then go on to some of the depositions and interviews from victims, as well as investigators, the request and called for the state attorney's office to be investigated, as well as look at all the individual parties that were involved in the cover-up and the investigation for Jeffrey Epstein. But for now, let's head over and see what the DOJ has prepped for us. This is my first time reading any of the files, so we'll be looking at all of this together. Okay, so let's get to it. So this is the DOJ website where the Epstein files have been released. It's called the Epstein Libraries, justice.gov/Epstein. There is zero gatekeepers on this channel. I want you guys to have all the information, know what I'm reading, which is why I've also created the Substack. So with every episode, all the files and investigative notes that we read and all like the resources that we look at will be uploaded as well. So you can follow along too and know that I am not here to gaslight you into anything by giving you straight facts, straight knowledge. Okay. So this is the Epstein library from the DOJ. I thought it would be good if we kind of see how everything is organized and we see it together. So we have two options. We have DOJ disclosures, including disclosures under Epstein files transparency, so that reduction of victim names and other identifying information have been applied. In audio files, reductions of victim names and other identifying information has been implemented through the use of a steady, solid tone. And then the second option is the Committee on Oversight Government Reform Disclosures. And that says the House Committee on Oversight and Government Reform released numerous Epstein records. Let's see what both of them have for us to offer. Let us start with the DOJ disclosures, and then we'll just open both of them up in a new window. How's that? Okay, so the first tab that I opened was the DOJ disclosures. It'll ask you if you're 18 years or older. Yes. Okay, so we have two tabs underneath here. Epstein Transparency Act, and that has 12 data sets. And there's a memoranda and correspondence, which is one file. We'll read that together. All right, so the next one we have is the Oversight Committee release Epstein file. Oh, I think this is the one from September. And they have backup access as well as related documents. Okay, so let's see what this has for us. Okay, so I went from the Oversight, I clicked here and the Oversight link, which led to this Google Drive. That's the options and the Google Drive. So it looks like this is videos and images. How many pages of images? Well, yeah, same. So 12 sets of images. And this is also 12 data sets. Share this tab instead. So it looks like even over here, the DOJ link for DOJ disclosures. Remember, I have two disclosures from the homepage. Let's go back to the homepage. So we have DOJ and then we have House Oversight Committee disclosures. DOJ tab led us to here that has 12 data sets to look at. Oversight led us to this tab or this website, which when I clicked here, then led us to this Google Drive, doc one that has images and natives appear to be videos of the information. But images, when we click, it also has 12 data sets. So maybe let us look at data set 1 and images 1. And if it's the same thing, then we know we can X-nay one of them. And I think I kind of want to stay online for this. I'm a little sketched out about like downloading new stuff from the DOJ. Even if it's the DOJ, like I don't know if it's spyware or whatever, these people are doing weird fugazi. So let's start by opening up the two sets and seeing what we have. All right, so here we go. So data set 1, let's open that up in the Google Docs for the images. Let's see, can we preview? Excuse me. Okay, so this is data set 1 from the House Oversight. Now to see if it's the same, let's see what data set 1 view files has from the DOJ. Okay, so this is pictures. Okay, so it looks like Oversight data set 1 is a document. This DOJ data set 1 is literally images. And this is of his New York apartment. So this must be when they're doing the search warrant for it has a date. This was done July 6th, 2019. Case number, photographer name is X-nayed out of it. And this is for the East 71st Street. So this is the New York condo townhouse for Epstein. It's the first one for the DOJ images data set. Now, remember we also clicked data set 1 in the House Oversight tab and committee. And this is Ghislaine Maxwell versus the Supreme Court. And this is, what it says, Undersigned Counsel pursuant to 28 U.S.C. declares that on the 15th day of January 2025, a copy of the petitioner's application for extension of time to file a certiorari petition was served by the U.S. mail upon the Solicitor General of the United States in room 56104, Miami. Okay, this has page 2. Okay. Is this a continuation case? Can't tell if this is the same DOJ, January 15th to 2025. was a petition to extension of time. Censory petition. What is that? Let me Google that quickly. It's a censory petition. Oh, awesome. Okay, so it looks like thingy one, where are we? Image one or whatever, document one of the House Committee appears to be all about Ghislaine Maxwell. I had to quickly pause and see what the certiorari petition was, and that is, ladies and gents, that is a petitioner's application for an extension of time to file a petition for writ of certiorari is a formal request made to the Supreme Court. Okay, so this is a petition from Ghislaine Maxwell to the Supreme Court in order to get some extension in time. And this was done in Miami, Florida, in January 15th and 25. Like, literally, this is all it says. And then no context. That's what I mean when I say literally. That's all it says. There's zero context to that. And then the very next document. The annoying thing is, like, literally, these PDFs have been uploaded. Instead of like a document or a PDF, they've been uploaded as JPEGs one by one. Why would they do, like, I'm thinking, like, why in the world would you do that instead of making it easier? And they could be uploading them as images one by one, so like it can meet their like fallacy of like the billions and millions of pages. You can create that of documents. You could create that by scanning every file as a JPEG one by one instead of a whole document. And it could just be also like there's so much information that they're hoping people won't actually like go through it and read it, and it's easier to like forget stuff or not notice stuff is missing if they give such huge dumps in such an inconvenient way. But again, that is my opinion. That is my rant. Let's move on to the next PDF/document in this file of images. So the next one is the United States Court of Appeals for the Second Circuit Court. It was a petition to the Supreme Court from Ghislaine Maxwell asking if she could have an extension, but there's zero context. It's just a scan and place there as the first document in this file. Then we go on to the second document, and that's the United States Court of Appeals for the Second Circuit August term in 2023. United States of America is the appealee versus Ghislaine Maxwell, also known as the sealed defendant 1, defendant appellant, on appeal from the United States District Court for the Southern District of New York. Argued March 12th, 2024, decided September 17th, 2024, before Cabranes, Wesley, and Lohier Circuit judges. I don't know if I said those names right. The page 2 states, defendant Ghislaine Maxwell appealed her June 29, 2022, judgment of conviction in the United States District Court for the Southern District of New York. Allison J. Nathan, judge. Maxwell was convicted of conspiracy to transport minors with the intent to engage in criminal activity in violation of 18 U.S.C., transportation of a minor and intent to engage in activity in violation of 18 U.S.C. and the trafficking of a minor in violation of 18 U.S.C. She was primarily sentenced to concurrent terms of imprisonment of 60 months, 120 months, and 240 months, respectively, to be followed by concurrent terms of supervised release. On appeal, the questions presented are whether 1. Jeffrey Epstein's Non-Prosecution Agreement and the United States Attorney's Office for the Southern District of Florida barred Maxwell's prosecution by the United States Attorney's Office for the Southern District of New York. Second, a superseding indictment of March 29, 2021 complied with the statute of limitations. And 3, the district court abused its discretion in denying Maxwell's Rule 33 motion for a new trial based on the claimed violation of her Sixth Amendment right to a fair and impartial jury. And 4, district court's response to a jury note resulted in a constructive amendment of or prejudicial variance from the allegations of the second superseding indictment by Maxwell's sentence was procedurally reasonable. Identifying no errors in the district court's conduct of the complex case, we affirm the district court's June 29, 2022 judgment conviction. So it looks like this was filed on September 17, 2024. And on appeal, the question of appeals was A, should she have even been convicted because of the NPA? The NPA should have barred her from being convicted. And it says something, the other argument was about the statute of limitations. The third argument was that she doesn't believe that she got a fair and impartial jury. And yeah, and then the fourth argument, constructive amendment of prejudicial variance from the allegation in the second superseding, and 5, procedurally reasonable. So they argue that her sentencing was or wasn't procedurally reasonable. I don't know. But anyway, the court found no errors in what they did, and they affirmed the conviction, is what this is saying. They affirmed the conviction and will not turn it over. So next, page 3, Andrew. Okay, so it is by Andrew Robach, Assistant U.S. Attorney Maureen Comey. She got fired, by the way. Maureen Comey got fired. She's no longer there. So it looks like these are the assistant attorneys who worked on it. And the circuit judge. So the circuit judge says, okay, so circuit judge's notes on this is that defendant Ghislaine Maxwell appealed her June 29, 2022 judgment. Okay, so this signing, correct me if I'm wrong, so the first part was the case and opinion of the district attorney's office, and they affirmed their decision. Then the next is Jose's opinion, who's a circuit district with it. And Judge Jose Cabranes, Circuit Judge Jose says, defendant Ghislaine Maxwell appealed her June 29, 2022 judgment of conviction in the United States District Court for the Southern District of New York. Allison J. Nathan was the judge. So was convicted of conspiracy to transport minors, intent and engage with criminal activity, violation 18 U.S.C. We just read all of that. Transportation of a minor with intent to engage in criminal activity, trafficking of a minor. They imposed concurrent 120 to 240 months in prison, plus supervised release. Let's see. So on appeal presented, it's the same, the NPA, whether or not the NPA is valid, whether or not she got the statute of limitations, same arguments as we read on the first page. And then it goes on to say, we hold that, so this is from the district judge, we hold that Epson's NPA did not bar Maxwell's prosecution by USAO SCNY. So U.S. Attorney's Office for Southern District of New York, as the NPA does not bind the U.S. Attorney's Office, Southern District of New York. And if you guys remember, Ghislaine Maxwell wasn't a part of that case when the NPA was drafted. It was Sarah Kellen, Robson, Nadia Marchinkova is listed in the NPA. Adriana is listed in the NPA, and Sarah Kellen is listed in the NPA. Haley Robson was never actually charged with a crime because obviously the cops had brains and senses to see she was just a minor who was also a victim in the whole. Okay, sorry, my bad. Keep doing that. I should need to stop. It goes on to say, so it did not, the NPA did not bar it. And then it says, we hold that Maxwell's indictment complied with the statute of limitations for 18 U.S.C., extended the time to bring charges for offenses committed before the date of the statute's enactment. So the whole Me Too law is also what has kept Maxwell in jail. Continues to say, we further hold that the district court did not abuse its discretion in denying Maxwell's Rule 33 motion for a new trial based on one juror's erroneous answers during voir dire. I have the voir dire, so we'll look at those too when we get into the 2019 cases. We're going to go in chronological order again. So we'll go 2019, then we'll go to 2016. 2005 when they started screaming for the case to be investigated. Then Epstein, then we'll go and see his time in jail, the committee when he got weekend jails, they could get food. So there we have all those logs. We'll go through those logs together. And then we'll go into the 2019 because that one's kind of like you need the whole story to go through it. Okay, so what else did you say? We also hold that the district court's response to a jury note did not result in the constructive amendment of prejudicial variance from the allegations of the indictment. Lastly, we hold that Maxwell's sentence is procedurally reasonable. Accordingly, we affirm the district's court's June 29, 2022 judgment of conviction. So, what we're looking at, it looks like Maxwell was appealing her conviction and sentencing based off mainly the NPA statute of limitation, obviously got thrown out, as well as whether her sentencing was reasonable or not, and whether or not she got a fair trial. So now it looks like after what we do need to know is that they threw out that appeal. She did not win that appeal. So now we go into the background. So the background states that the defendant, Ghislaine Maxwell, coordinated, facilitated, and contributed to Jeffrey Epstein's women and underage girls starting in 1994. Maxwell groomed young women to engage in activity with Epstein by building friendships with these young women, gradually normalizing discussions of topics until about 2004. This pattern of continued as Maxwell provided Epstein access to underage girls in various locations in the United States. I just thought of like, all this has been released, but all I've been literally seeing on TV is like videos and redacted videos of like Epstein dancing and stuff. But I haven't really seen much of like the court files and papers. They're not mentioning it. They just want like the funny sensationalism part of it, not the hard facts. So it goes on to say Epstein's NPA 1. So in September 2007, following the state and federal investigations into allegations of Epstein's unlawful activity, Epstein entered into an NPA with the U.S. Attorney's Office in Southern District of Florida. In the NPA, Epstein agreed to plead guilty to one count of solicitation in violation of Florida statutes and to one count of solicitation of minors to engage in violation of statutes. He agreed to receive a sentence of 18 months of imprisonment on the charges. In consideration of Epstein's agreement, the NPA states that the United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to Sarah Kellen, Adriana Ross, Leslie Groff, or Nadia Machinkova. Remember, I told you Ghislaine wasn't part of this in the beginning. And this is what we're looking at right now. So if this is your first time catching us, what we're looking at right now is the investigation and the grand jury and the NPA negotiations that took place, like all the tomfoolery that happened back and forth between the attorney's office in Florida, as well as the numerous and huge ever-changing defense team that Jeffrey Epstein had, with one lawyer that was with him throughout it till the end, which was Dershowitz. Anyway, we continue. So number 2 of the background states Maxwell's indictment and trial-related proceedings. The indictment filed against Maxwell contained 8 counts, 6 of which proceeded to trial prior to commencement of trial. Prior to the commencement of the trial, this is about the fair trial and voir dire. Okay, so prior to the commencement of the trial, prospective jurors completed a lengthy questionnaire with several questions raising issues relevant to the trial. Based on the completed questions, the party selected prospective jurors to proceed to in-person voir dire. The district court ultimately impaneled a jury. During the 4.5-week jury trial, the government presented evidence of the repeated 6 girls. At the conclusion of trial on December 29, 2021, the jury found Maxwell guilty on all but 1 count. Following the verdict, Juror 50 gave press interviews during which he stated that he was a survivor of child sex. In the answers to the written jury question, however, Jury 50 answered no to 3 questions asking whether he or a friend or family member had ever been the victim of a crime, whether he or a friend or family member had ever been the victim of harassment, assault, and whether he or his friend or family member had been accused of harassment, or assault. Upon learning of the interviews, the government filed a letter on January 5th, 2022, requesting a hearing. Maxwell then moved for a new trial under Federal Rule of Criminal Procedure 33. So, on March 8th, 2022, the district court held a hearing and Juror 50 testified under grant of immunity that his answers to 3 questions related to in the jury questionnaire were not accurate, but that the answers were an inadvertent mistake and that his experiences did not affect his ability to be fair and impartial. Finding Juror 50's testimony to be credible, the district court denied Maxwell's motion for a new trial and a written order. Plus, it's like Maxwell was subsequently sentenced to a term of 240 months of imprisonment, followed by 5 years of supervised release. And the district court imposed a $750,000 fine and $300 mandatory special assessment. This appeal followed. Okay, so discussion number 2. All right, so just to go over it, the NPA was the one thing, and they said, no, the NPA doesn't cover you because it was for Florida. And we already know that Ghislaine was not part of the original investigation and charges. So that was thrown out. 2, the other argument was that she deserved a new trial because one, remember, after she was sentenced, did interviews saying he was a survivor of childhood, but he had answered no in the voir dire. He went and said they had another trial where he was able to testify without threat of being sentenced, with immunity is the word I was looking for. And they believed him enough to think that his experience did not affect him being partial. So they denied that too. So that's the background of her appeal. Now we're moving on to the discussion. Okay, pause. Okay, next we go to the discussions. The NPA between Epstein and U.S. Attorney Office, Southern District of Florida, did not bar Maxwell's prosecution by United States, Southern District, New York. Okay, let's see if my assumptions were right about why the NPA did not cover her. So the discussion goes on to say, Maxwell sought dismissal of charges in the indictment on the grounds that the NPA made between Epstein and the U.S. Attorney Office, Southern District of Florida, immunized her from prosecution on all counts as a third beneficiary of the NPA. The district court denied the motion, rejected Maxwell's arguments. We review de novo the denial of the motion to dismiss an indictment. Goes on to state that in arguing that the NPA barred her prosecution by United States Attorney's Office in the Southern District of New York, Maxwell cites the portion of the NPA in which the United States agreed that it would not institute any criminal charges against any potential co-conspirators of Epstein. We hold that the NPA with the United States Attorney's Office in Florida does not bind the one in New York. And for those who are following along, in the NPA itself, it does state that. They try to wash their hands of it and in the best way make sure that what happened in Florida did not affect them as much as in New York later on. Anyway, we'll get there. It goes on to say it is well established in our circuit that a plea agreement binds only the Office of the United States Attorney for the district in which the plea is entered unless it affirmatively appears that the agreement contemplates a broader restriction. And while Maxwell contends that we cannot apply Anabbi to an agreement negotiated and executed outside of this circuit, we have previously done just that. Applying Anabbi, we conclude that the NPA did not bar Maxwell's prosecution from the U.S. Attorney's Office in New York, Southern District of New York. There is nothing in the NPA that affirmatively shows that the NPA was intended to bind multiple districts. Instead, where the NPA is not silent, the agreement's scope is expressly limited to the Southern District of Florida. The NPA makes clear that if Epstein fulfilled his obligation, he would no longer face charges in that district. And it looks like a quote. It says, after timely fulfilling of the agreement, of all the terms and conditions of the agreement, no prosecution for offenses set out on pages 1 and 2 of this agreement, nor any other offenses that have been the subject of the joint investigation by the Federal Bureau of Investigation and the United States Attorney's Office, nor any offenses that arose from the federal grand jury investigation will be instituted in this district, and the charges against Epstein, if any, will be dismissed. We go over the NPA and the discussions between Lana, who was the Southern District of Florida district attorney that really championed Epstein. We'll go over the emails and discussions she had between Epstein's and his defense. And actually, Epstein's defense counsel in New York brought up these exact points as they were trying to negotiate the NPA back and forth. So you guys will get a glimpse into the back end of that as well. So again, hit subscribe so you have all the details and you don't miss a thing. But we have all the background negotiations of the NPA as well. Okay, let's continue. So goes on to say the only language in the NPA that speaks to the agreement's scope is a limiting language. And it says it. So this is another quote from the NPA. It says the negotiation history of the NPA, just as the text, fails to show that the agreement was intended to bind other districts. I believe that was done very intentionally. Under our court's precedent, the negotiation history of an NPA can support an inference that an NPA affirmatively binds other districts. Yet the actions of the United States Attorney's Office in Florida do not indicate that the NPA was intended to bind other districts. They couldn't get that. I'm sure if they could have gotten to bind for other districts, they would have, but they could not get that. And I believe that is why Epstein ran away to the Virgin Islands. Goes on to say, the United States Attorney's Manual that was operable during the negotiation of the NPA required that no district or division shall make any agreement, including any agreement to prosecute, which purports to bind any other district or division without the express written approval of the United States attorneys in each affected district and or the assistant attorney general of that criminal district. So saying without the express agree from, say, SCNY, for example, which is directly this one, or say Texas or whatever, they can't bind you in an NPA. Florida couldn't bind other people. So then I see A7, what is this, bibliography? Just bottom of this, went back one page, says number 3, A75, emphasis added. The agreement scope is also limited in additional section. Therefore, on the authority of R. Alexander Acosta, United States Attorney of Southern District of Florida, prosecution in this district for these offenses shall be deferred in favor of prosecution by the state of Florida, providing the Epson abides by the following conditions and requirements of this agreement set forth. Okay, so this is just a direct quote from the NPA. We got that. We'll get to it. We're getting back to it on Monday, guys. Don't worry. I thought literally we're just going every single thing that we're opening today was just going to be images and videos because that's all I've seen on the news, on CBC, BBC, CNN, whatever. All the news, I've just seen images of pictures and videos. I didn't think there was any documents in there to go through. So we were, okay, yeah. We already read this. This was just saying that Florida cannot bind other districts into an NPA without their expressed agreement. So then it goes on to say nothing before us indicates that United States Attorney's Office in the Southern District of New York had been notified or had approved of Epstein's NPA with the Southern District of Florida and intended to be bound by it. And the Assistant Attorney General for the Criminal Division stated in an interview with the Office of Professional Responsibility that she played no role in the NPA either by reviewing or approving the document. So I'm thinking, and the Assistant Attorney General for the Criminal Division. So I'm thinking that's the one in New York said they never reviewed it. So my name is Bennett and I ain't in it. When it came to the NPA, we do have those documents for the Office of Professional Responsibility. So that will be after the grand jury is when we'll look at all this and into the SORA. It's coming up, maybe a couple weeks. We're getting through it as fast as we can anyway. And the next thing it says, the history of the Office of the United States Attorney is instructive as to the scope of their actions and duties. The Judiciary Act of 1789 created the Office of the United States Attorney along with the Office of the Attorney General. More specifically, The Judiciary Act provided for the appointment in each district of a person learned in the law of act as attorney for the United States in such a district, who shall be sworn or affirmed to the faithful execution of his office, whose duty it shall be to prosecute in such district all delinquents for crimes and offenses cognizable under the authority of the United States, and all civil actions in which the United States shall be concerned. The Judiciary Act thus emphasized the U.S. Attorney's Office should enforce the law of the United States, but did not determine that the actions of one U.S. attorney could bind the other districts, let alone the entire. Okay, all right. Okay, so this whole paragraph is just stating that it is the duty of a person in the United States Attorney's Office to act in the best interest of the state and prosecute all delinquents and criminals, but it doesn't say that one attorney's actions can bind all U.S. attorneys, is basically what this entire paragraph is saying about the history of the U.S. Attorney's Office. Goes on to say the actions and the duties of the U.S. Attorney's Office would be limited to their own districts, absent any express expectations. Since 1789, while the number of federal districts has grown significantly, the duties of the U.S. Attorney and their scope remain largely unchanged. By statute, U.S. attorneys within their district shall prosecute all offenses against the United States, prosecute or defend for the government all civil actions, suits, or proceeding in which the United States is concerned. Again, the scope of the duties of a U.S. attorney is cabined to their specific district unless otherwise directed. In short, Anabbi controls the result here. Nothing in the text of the NPA or its negotiation history suggests that the NPA precluded the USAO SDNY, Southern District of New York, from prosecuting Maxwell for the charges in the case in the indictment. The district court therefore correctly denied Maxwell's motion without evidentiary hearing. Denied Maxwell. Stay in jail. Okay, so before we go forward to the next portion of the discussion, I wanted to see what the role of Anabbi was, and that is a statutory interpretation derived from a case of U.S. versus Anabbi, the often cited in the Southern District of New York, establishes clear statement rule regarding plea agreements, limitations, three-party scheme, and substantive application law. So exactly what we're just talking about was whether or not New York was bound by the terrible NPA that Florida and Bella Hell went on to pen and negotiate for Epstein and his cronies. Anyway, so we move on to number 2. The second discussion and the second argument was the statute of limitation or the timely indictment. So Maxwell argues that the counts 3 and 4 of the indictment are untimely because they do not fall within the scope of offenses involving the sex or physical or kidnapping of a minor, and thereby do not fall within the extended statute of limitations provided by 3283. Separately, Maxwell contends that the government cannot apply the 2003 amendment to 3283 that extended the statute of limitations to those offenses that were committed before the enactment into law of the provision. On both points, we disagree and hold that the district court correctly denied Maxwell's motions to dismiss the charges as untimely. We review de novo the denial of a motion to dismiss an indictment and the application of the statute of limitations. First, counts 3 and 4 of the indictment are offenses involving the sex minors. District court properly applied Weingarten versus United States. In Weingarten, we explained that Congress intended courts to apply 3283 using a case-specific approach as opposed to a categorical approach. We see no reason to depart from our reasoning in Weingarten. Accordingly, the question presented here is whether the charged offenses involving this of a minor for the purposes of 3283 based on the facts of the case. Jane That's August Jane Doe. One of the women who testified at trial gave evidence that she had been then transported across state lines as a minor. Counts 3 and 4 thus qualify as offenses in and 3283 applied to those offenses. Next, second, Maxwell argues that counts 3 and 4 and 6 of the indictment are barred by the statute of limitations because the extended statute of limitations provided by the 2003 amendment does not apply to pre-enactment conduct. In Landgraf versus U.S. Film Products, the Supreme Court held that a court, in deciding whether a statute applies retroactively, must first determine whether Congress has expressly prescribed the statute as it is written. If the statute is ambiguous or contains no express command regarding retroactivity, a reviewing court must determine whether applying the statute to the anecdote conduct would create presumptively impermissible retroactive effects. Here the inquiry is straightforward. Congress amended 32A provide no statute of limitation that would otherwise preclude prosecution for an offense involving this or physical or kidnapping of a child under the age of 18 years shall preclude such prosecution during the life of the child. The text of 3283, the no statute of limitations would otherwise preclude prosecution of these offenses will apply, plainly prevents the application of a statute of limitations to any pre-conduct. So statutes of limitations does not apply in the or physical or kidnapping of a child at all is what I'm reading for this. So her argument is denied because 3283 says zero statute of limitations for any past conduct for life. It goes on to say the statutory text makes clear that Congress intended to extend the time to bring charges of full pre-enactment conduct as the prior statute of limitations was inadequate. This is enough to conclude that the Protect Act amendment to 3283 applies to Maxwell's conduct as charged in indictment. So number 2, wrong. Statute of limitations, can't argue because there are minors, there's children, so there's zero statute of limitations in these cases. Got it. Moving on to argument number 3 is the district court did not abuse its discretion in denying Maxwell's motion for a new trial. Because if you remember, she asked for a new trial because of the jury number 50. So now they're telling us why they said Maxwell contends that she was deprived of her constitutional right to a fair and impartial jury because juror 50 failed to accurately respond to several questions related to his history as part of the jury questionnaire. Jury selection. Following a special evidentiary hearing, the district court denied Maxwell's motion for a new trial. We review a district court's denial of a motion for a new trial for abuse of discretion. We have been extremely reluctant to hold jurors in after they have reached a verdict in order to probe for potential instances of bias, misconduct, or extraneous influences. While courts can vacate any judgment and grant a new trial if the interest of justice so requires, they do so sparingly and only in the most extraordinary circumstances. So right now it's saying, hey, Maxwell asked for a new trial because of juror number 50, who was the guy, as we recall, said he was never, his family members, or anyone knows, was never a victim of. And then he later did interviews saying he was a survivor of childhood. And they're saying that as the court, we usually don't like to bring people in. And when we do it, it is very sparingly. Okay. Next. So, next paragraph. Discretionary Rule 33 motions are based on its evaluation of proof produced and is shown deference on appeal. So they're saying again, if we do decide special circumstances, and it's based on our evaluation. So then it goes on to say a Rule 33 motion based on a juror's alleged erroneous response during a voir dire is governed by McDowell Power Equipment Inc. versus Greenwood. Under McDowell, a party seeking a new trial must first demonstrate that a juror failed to answer honestly a material question on a voir dire, and then further show that the correct response would have provided a valid basis for challenge for cause. Okay, so now let's look at the history of this case. The district court applied the McDowell standard, found jury 50's testimony credible, and determined that jury 50's erroneous responses during voir dire were not deliberately incorrect, and that he would not have been struck for cause if he had provided accurate responses to the questionnaire. In fact, as the district court noted, Maxwell did not challenge the inclusion of other jurors who disclosed past experience with assault, abuse, or harassment. See, that makes more sense because I was like, are they going to tell us why they think him credible? But if you have allowed other people who've gone through this, why would you then want a whole new trial because of this one guy? Because you didn't know when there was other people who were survivors as well. So it goes on to say the district court did not abuse its discretion in denying Maxwell's motion for a new trial. All right, move on to the next argument. 4 was the district court's response to a jury note did not result in a consecutive amendment of or prejudicial variance from the allegations in the indictment. Argument 4 goes on to say, during jury deliberations, the jury sent the following jury note regarding count 4 of the indictment. Under count 4, if the defendant aided in the transportation of Jane's return flight, but not the flight to New Mexico, where if the intent was for Jane to engage in activity, can she be found guilty under the second element? So this is the transportation of a minor. So she was involved in the return flight, but not the flight to. All right. So they're asking, because she didn't book the flight to, but only booked the return flight, is she still responsible? Next, it says the district court determined that it would not respond to the note directly because it was difficult to parse factually and legally, and instead referred the jury to the second element of count 4. Okay, so Maxwell subsequently filed a letter seeking reconsideration of the district's response, claiming that this response resulted in a constructive amendment of prejudicial variance. The district court declined to reconsider its response and denied Maxwell's motion. Maxwell appeals the district court's denial and argues that the alleged constructive amendment in a per se violation of the grand jury clause of the Fifth Amendment. Specifically, Maxwell argues that testimony about a witness in New Mexico presented the jury with another basis for conviction, which is distant from the charges of the indictment. Similarly, Maxwell argues that this testimony resulted in a prejudicial variance from the indictment. We disagree and affirm the district court's denial. We review the denial of a motion claiming a constructive amendment or prejudicial variance de novo. To satisfy the Fifth Amendment grand jury clause, an indictment must contain the elements of the offense charged and fairly inform the defendant of the charge against which he defended. We have explained that to prevail on a constructive amendment claim, a defendant must demonstrate that the terms of the indictment are in fact altered by the presentation of evidence, and jury instructions were so modified essential elements of the offense charged, and there is substantial that likelihood the defendant may have been convicted of an offense other than the charged indictment. So jury note did not result in constructive amendment of a prejudicial variance from the allegations of the indictment. So the note said that if the defendant, who was Ghislaine, paid for the return flight from New Mexico, where Jane Doe was assaulted, but did not pay for the flight to, can she be held guilty? And then when the court decided not to respond to the note directly, because it was too difficult to parse factuality and legally, and told them instead to refer to the second element of count 4. Okay, so we're back. I found Ghislaine's original indictment, so we understand exactly what's going on with this count for. So again, they're saying the jury note was if she only participated in arranging the flight home, not the flight to New Mexico, can she still be found guilty? So count one was conspiracy for minors to travel, to engage in illegal acts. Under that count. We'll look over these later, don't worry, guys, in more detail. I just want to understand exactly what was happening here. Told you guys I got the unredacted stuff. Maxwell's efforts to conceal her conduct. Okay. I think we're still count. Oh, that's so count three. And where's count four? So we understand what okay, so count four is transportation of a minor with the intent to engage in criminal activity. Got it. So what I am reading off this is that when they say it's hard to per se and legally and refer the jury to the second element of count four, I think I believe that means instead of considering the transportation, let's focus on the intent. Okay. Which is okay. Now I get it. Okay. They said, okay. So when they asked, they said, we can't, it's too hard to like define, like differentiate legally and like per se between the two. Focus on the second part, which is the intent. The intent is for the minor victim to engage in illegal act. So now it makes sense when they say, when they review, part of the review thing is that if it had been like it would lead them to be charged with something else. So like the Diddy case. Remember with the Diddy case, how it was like, we're not charging him for domestic violence. And then that's how we kind of got away with it. Best way to like do apples and oranges, apples to apples is with Diddy, the case was for like trafficking and stuff, but it was not for domestic violence. So in this case, if the jury had sent a note to the judge, say, we're going to use Diddy's thing, and it was to do with something similar, then maybe they would have agreed to the appeal because of the two different charges, right? We're there for this new evidence that you're presenting to us, or this instruction is about domestic violence. But when it comes to Ghislaine Maxwell's, like the prejudicial variance, why it was de novo and why it doesn't work, is that it is all at the end the same charge. Everything is about being involved, I guess the best way to say, with the delinquency of minors for the intent of illegal acts. And that is why that appeal was not accepted and denied. I hope it makes sense. I hope I'm right. If I'm not right and there's any like lawyers in the comments, please let us know in the comments below. Substack, we can have conversations there too. If there's another community board that you guys actually prefer for us to use, let me know. Like I said, new channel, figuring it out. Let me know what the best way for us to really discuss these topics and the truth and the facts about this in a clear, concise manner for anybody and everybody. Okay, let's continue. All right, I think we finished all this. It was just, I had to go back to figure out why they said no and what it means. So the court, then the final said why we cannot conclude. So their decision on it, now that we understand what count four was, it says we cannot conclude that the constructive amendment resulted from the evidence presented by the government, namely Jane's testimony, or that it can be implied from the jury note. We have permitted significant flexibility in proof as long as the defendant was given notice of the core criminality to be proven at trial. In turn, the core of the criminality of an offense involves the essence of a crime in general terms, the intent. The particulars of how a defendant affected that crime falls outside purview. We agree that the district court we agree with the district court that the jury instructions, the evidence presented at trial, and the government's summation captured the core of criminality and trafficking of minors. While, exactly, so Diddy, it was domestic violence, domestic abuse versus, as the district court noted, while the jury note was ambiguous in one sense, it was clear that it referred to the second element of count four of the indictment. Therefore, the district court correctly directed the jury to that instruction, which accurately instructed that count four had to be predicted on a violation of New York law. It is therefore not uncertain whether Maxwell was convicted of conduct that was subject of the grand jury indictment. We also cannot conclude that the evidence at trial prejudicially varied from the indictment. It did not. To allege a variance, the defendant must establish that the evidence offered at trial differs materially from the evidence alleged in the indictment. Diddy was able to prove that by saying, "We are not here to argue domestic violence. We're here arguing." Next, it says, to prevail and win reversal, the defendant must further show that the substantial prejudice occurred at trial as a result of the variance. A defendant cannot demonstrate that he has been prejudiced by a variance where the pleading and the proof substantially correspond, where the variance is not of a character that could not have misled the defendant at mistrial, and where the variance is not as to deprive the accused of his right to be protected against another prosecution for the same offense. So if the variant is not introducing other crimes and you know exactly what it is, and it goes on with the entire essence of the case, you have no argument, is what they're saying. For reasons similar to the ones noted above, in the context of the constructive amendment, the evidence at trial did not prove the fact. Maxwell transported Jane to New York and conspired to do the same. Maxwell knew that the evidence also included conduct in New Mexico. Furthermore, Maxwell cannot demonstrate substantial prejudice. Maxwell received over 3 weeks before trial notes of Jane's interview recording. The abuse she suffered in New Mexico. This is enough to conclude that Maxwell was not unfairly and substantially prejudiced. Maxwell can stay in jail. Okay, so argument 5 is the last argument that she had, was that her sentence was procedurally reasonable. And number 5 says, lastly, Maxwell argues that her sentence was procedurally unreasonable because the district court erred in applying a leadership sentencing enhancement under the sentencing guidelines and inadequately explained its above guideline sentencing. We disagree. So they did not explain to her. She did not understand what the sentencing guidelines would be. Ooh. So it goes on to say, we review a sentence. So it goes on to say, review a sentence for both procedural and substantive reasonableness with amounts to review for abuse discretion. We have explained that procedural error is found when a district court fails to calculate or improperly calculates the sentencing guidelines range, treats sentencing guidelines as mandatory, or fails to consider the factors. Select a sentence based on clearly erroneous facts or fails adequately to explain the chosen sentence. The court did that. The district court did none of that. It is important to emphasize the sentencing guidelines are guidelines, that is, they are truly advisory. A district court is generally free to impose sentences outside the recommended range based on its own informed and individualized judgment. With respect to the 4-level leadership enhancement, the district court found that Maxwell supervised Sarah Kellen, there she is again, and she's not in jail, Sarah Kellen, in part because of testimony from 2 Epson pilots who testified that Kellen was Maxwell's assistant. But in the beginning, she was Jeff's assistant. The district, but in the beginning, she, in the police notes from 2005, all the victims knew her as Jeffrey Epstein's main assistant who would book the massages. The district court found the testimony credible, in part because it was corroborated by other testimony that Maxwell was Epstein's number 2 and the lady of the house in Palm Beach, where much of the abuse occurred and where Kellen worked. We therefore hold that the district court did not err in applying the leadership enhancement. Okay, so she was charged as leading the conspiracy with the leadership thing, because they said she trained Kellen or whatever. Kellen was her assistant. This girl, she's everywhere, and she is living her free life out there, having fun, I don't know, dating, whatever. She's out there living a full life. when her dirty little paws, Sarah Kellen's dirty little paws, are all over this Epstein things. Okay, so it goes on to say, with respect to the length of the sentence, the district court properly discussed the sentencing factors when imposing the sentence and described at length Maxwell's pivotal role in facilitating the abuse of underage girls through a series of deceptive tactics. Goes on to read that with respect to the length of the sentence, the district court properly discussed the sentencing factors when imposing the sentence and described at length Maxwell's pivotal role in facilitating the abuse of the underage girls through a series of deceptive tactics. The district court recognized that the sentence must reflect the gravity of Miss Maxwell's conduct, of Miss Maxwell's offense, the pivotal role she played in facilitating the offenses, and the significant and lasting harm it inflicted. And the district court explained that a very serious, a very significant sentence is necessary to achieve the purpose of punishment. In sum, the district did not err by failing to adequately explain its sentence to Ms. Maxwell, and that concludes. We summarize as follows. Last page. It says, the conclusion is 1. The district court did not err in holding that Epstein's NPA with the United States Attorney's Office in the Southern District of Florida did not bar Maxwell prosecution by the United States Attorney's Office in the Southern District of New York. The district court did not err in holding that the indictment was filed within the statute of limitations. 8. The district court did not abuse its discretion in denying Maxwell's Rule 33 motion for a new trial. 4. The district court's response to a jury note did not result in a constructive amendment of or prejudicial variance from the allegations of the indictment. And 5, the district court's sentence was procedurally reasonable. So, for the foregoing reasons, we affirm the district court's June 29, 2022 judgment of conviction. So, in the end of this document, what we know is Ms. Ghislaine Maxwell's appeal to dismiss her conviction was denied on all 5 fronts. This looks like who is this? This is just the last page of the appeal as stated in the terms, blah, 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 and the docket number and the filing. And okay, so that's done. And what is this? We have one more here. And this looks like this is a Supreme Court petition. Again, Ghislaine Maxwell. I think they probably released all this Ghislaine Maxwell stuff to make them look a little bit better, but it's crazy how this is from the Oversight Committee, not the DOJ. Literally, the DOJ seems to just be pictures and videos that they've gone through sparingly. So I thought that it was maybe a couple pages. And so I took a pause to kind of like see what we're looking at and what would be forward. And that was like, 20 minutes ago. And I'm still scrolling, trying to get to the bottom of this entire folder. So what I've done is, I use Gemini to kind of like narrow down the content of this file for us so we can see what's in it. And then what I'm thinking is, so at the end of this video, I'm going to wrap it up here soonish. Like once we kind of just go over it, at the end of this video, what I'm going to do, I'm going to put a thingy at the bottom, a quiz or a poll at the bottom of this video and in the community post. And we can choose together what part of this we want to look at next. Like so many files, there's so many different like things, and they did it in the most inconvenient possible freaking way ever. So that's what we'll do. At the end of this, there'll be a poll. You get to vote which topic or which files you want to look at next from this document of this stuff. What I did was I used Gemini to go through the files and compile a list of everything that I have. See, still, I honestly thought it would just be images and pictures and videos because that is all I've seen being reported on like the mainstream media and all that stuff. But it looks like there's a bit more from at least the House committee. Okay, so don't worry. This is what it did for the images, so happy to help analyze. So the image folders have bail and financial conditions. This is detail of Ghislaine Maxwell's bail application and a pledge of assets by herself and her spouse and arguments. Her spouse, is that, I know she was married. Okay, so that is one thing that took the full bail and financial documents with her. So what I'm thinking we should do is at the end of this video, I'm going to put a quiz, a little poll, and you guys will get to decide, because I keep saying, like, this is a freaking team effort and a group effort, and I want us to do it together. So this is me telling you to join the efforts and as a team, because I tell you, they're only going to report it as long as it's getting them the clicks and views they need, and they're only going to report what their sponsors, their bosses, their media teams will allow them to report. So it's going to take a team of people to keep pushing this out and make sure that this stuff gets through. This is grassroots. It's just me. It's just you. It's just our little group here. No sponsors, no corporate funding, just independent, trying to get this information out. So what we're going to do is the first thing. So we're going to go through and see what is available in this file folder. I will have a poll at the end of this. Let me know what you want to see next. I'll be looking at the poll on Friday, and then Sunday we'll go over whatever documents we all just want to look at together on Sunday night again. And then, of course, during the week, we'll continue going through all the police notes. Okay, so then the next set of documents, according to Gemini in the package, in the file folder is the NPA agreement, and this is a significant portion of files arguing the NPA for Jeffrey. Oh, we just read part of that. We just read that. So that's what we just read with the NPA and her appeal. There's some superseding indictment and discovery information. Filing addressed the superseding indictment, which extended with conspiracy. Oh, this is Ghislaine Maxwell's indictment, which I did show you from my own papers. And actually, we're going to go back and forth to see if it's the same redacted, if they redacted more stuff in what they provided that is redacted in the other papers that I have. But we have that, so we can go through that to the indictment and discovery. But I have subpoenas for Ghislaine. So this is all Ghislaine Maxwell, what you want to look at for next Sunday. We have the subpoenas, the rest of the NPA information, and bail requests. So we did look at the final opinion that denied her appeal to get her conviction thrown out. We read that in those file papers as well. The next one was the actual first initial document or request, like filing from Ghislaine and defense to the circuit court for the appeal. I can put that all together as one with the NPA. And actually, maybe with the NPA, if you do vote, if the NPA does win, we can put all the documentations and information that I've collected and that is in here that are to do with the NPA. Then we can all do that at once next Sunday if that's what you vote for. Superseding indictment and discovery for Ghislaine Maxwell. So it says filings addressed the indictment, which extended the conspiracy through to 2004 with new trafficking charges. Fined victim number 4, defense counsel. Proceeding judgment, I just showed you that. Do you want to go? So with the superseding judgment, we can kind of like maybe put that all together. Now, you know what? There's so many papers. They said there's over 200,000 photographs. So judgment and discovery, let's leave that. That's all together. So next Sunday, with your help, we can look at the Ghislaine Maxwell information. Get to pick one. Like you can see, it's a lot of heavy, dense documents. I thought this was going to be like 30 minutes going through, but look how long. I had to take a break in the middle and find something to eat. And we have court orders on redactions and sealing. So with the DOJ, like DOJ rulings, and then we have subpoenas. So these are the categories. I will put those different categories in the quiz and poll at the end. Make sure you take it so we know exactly what documents we're going to look at next Sunday. And what's today? Today's the 8th. So next Sunday should be the 16th, 15th. So we'll look at all this on the 15th, whichever one you select for the 15th. Now, this is what we have for the Oversight Committee. Do you remember we got this for the Oversight Committee, and that was separate from the DOJ. So the DOJ is releasing separate files, it appears, than the House Oversight Committee. There we go. Here we go. Now that's the Oversight Committee's website. And when I clicked here, it took us over to this right here. into this Google Drive that is available. I will have the text below if you want to kind of look at it for yourself and go through the documents as well, which also brought us then to this file folder, which brought us to both images and natives. Images, we've only looked at image folder 1. This one is the one that we opened with over 2,000 in it, and that's the one we're going to vote on to see where we go next Sunday with Ghislaine Maxwell's case. And we can go through the other file folders as well. I'll let you know when I go through each of them. I'll put it in the community post this week. Once I go through it, the other stuff that's in this images folder. Before we continue, oh, I didn't even share the tab. Oh yeah. Before we continue, I want us to look at what the DOJ has released. All right, so with the DOJ filings, give me just 1 second. I have a whole bunch of them open. Share tab and stuff. Boom. So remember the DOJ had 12. Here we go. 12 data sets. DOJ and House Committee have different data sets of what they sent out from. So now we're going to do just a quick glance at what the DOJ set out, and I have them all opened. And I have them all open here for us to go through. And remember, like I was saying again, DOJ has 12 data sets to look over. And I thought we should just quickly go through these data sets. The House Oversight Committee turned out to be a lot of work just to see what this is. So we have open it data set 1. This is from the DOJ, what they've released. And it looks like data set 1, I believe it's how many pages? Let's see. Sharing that, yeah. Let me make this its own window so we can quickly, like pop, 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 open all of them. I like to start at the end. I'm one of those people who read a book. Sometimes when I read a book, I will read, if I'm like really into it, I'll read the ending of the book before I finish it. Because I like to. Then you already know what to expect. This is taking a while. And 64. Okay, so DOJ dataset 164. So why I thought it was pages, because I did look, I would take a sneak peek and it looked like it was what I saw at first was just these 5. Literally did look like they were just images from the DOJ. So let's open them up first, and then fingers crossed I win this battle over the ADHD, and I remember to actually like switch the sharing. Okay, yes, share this tab. So PDF 1. The DOJ dataset 1, like I said, pictures. Description of photographic miscellaneous items. And it looks like this, well, the photographer has taken probably like a search at 2019 search right here. August 16, 2019, there's a case ID for this. Office of who? You cannot read these people as hiding. Okay, wait, say maintenance, location, Little St. James USVI main office. Okay, so this looks like it's stuff that they collected from Epstein's home during the USVI investigation. All right, and what does it says? Cover sheet, entry office area, and everything's a number. Oh, the photos. So it's the photos that were picked up. Deed on wall, desk, closets, computer serial numbers, office, small office area. So it looks like it's just like kind of like an itemized list of what was collected during the USVI investigation. Photo logs, documents of office, extra small office. It just looks like inventory logs from USVI. No, and yes, they have to like verify age, I guess, for every single one. Okay, so I guess this is one of the offices that they're saying always clean and replace tools or garage. Say anything about it? Small office, staff office, computer in small office. Is there a computer in this office? Maybe there's 2 keyboards in there. Let's see. Yes. Sharon, we are over 18. Again, another office. When I first saw this, for some reason I thought these were referencing Detective Joe. Like I think it was either Alessi's or one of the housekeepers in Palm Beach. I thought it was one of offices or the garage, because it kind of looks like it could be a garage area. But I guess this is in the USVI. I don't know. This is at the house or what is that? Anne Rodriguez, front of deck, June 3rd, 2015. Richard Kahn. Richard Kahn is and Daphne Wallace. Who's Daphne? Richard Kahn is he's a lawyer, associate, part of the Epson estate. Again, watch the USVI playlist to catch up on those people's sins and dirty deeds. But it looks it's just nothing. Just the front deck. Anna Rodriguez. I want to know who Anna Rodriguez is. Let's see. Let's Google that quickly. Anna Rodriguez. Anne Rodriguez popped up for Epstein. Who is Anne Rodriguez? No one seems to. So I'm not the only person who's Epstein's Barge sued for damages in Arma. Found it November 5th, 2018. You always gotta dig, guys. When you dig, you find the answers. Anne Rodriguez, I saw this, and that's why I was Googling, and it's a picture of the front of the deck. And it does look like a barge, so which is why I then, and that was to Richard Kahn, and I was letting you guys know that Richard Kahn's one of his lawyers. So it was from Anna to Richard Kahn, and it said something with CC was Daphne Wallace. So when I went to Google for backup page, so you can see for Anne Rodriguez Epstein, I found the Virgin Islands Daily News about his barge being sued during Hurricane Irma. So I believe that's what it says. And here the article says, financier Epstein's barge is named in federal lawsuit regarding damage caused to Crown Bay Marina, alleging the vessel was improperly secured during Hurricane Irma. So that's the picture we saw. So that's what that email is for. St. Thomas, when was Irma? After we read this, we'll see when Hurricane Irma happened. St. Thomas attorney Matthew filed a lawsuit on behalf of the Crown Bay Marina and Transportation for the 70-foot transport barge. The lawsuit claimed the defendant company entered into an agreement in 2017, and 3 days later, Hurricane Irma, causing White's destruction. Defendant inadequately secured a big end barge and its boat slipped in the marina. Irma approached and then made landfall in Thomas. Okay, this was supposed, so when was, we're going to look. So the agreement was in 2017. The lawsuit claimed that the barge caused heavy damage to the concrete finger piers, pilings, blah, blah, over $70,000 in damages and expenses. Lawsuit seeks maritime license agreement for dockage, identifies Anne Rodriguez as the captain. So she was the captain of Big M Barge. That's how she ended up on there. Epstein 65 owns Little St. James Island off the East End. So why I was hesitating, if anybody caught that, was because I thought, I'm like, June 17th. So Anne Rodriguez was the captain of this barge, and I guess that's just an email that she was sending to Richard Kahn, who is his lawyer, in 2015 about it. Okay, so, and then the next, share this tab, and instead, gotta verify we're over 18. And this one is a list of Epstein employees. I am guessing, let's see, anything look familiar? Charles Dick, Garth employees, Ashley Etienne, Face, Charles Dick, Herrera, David Alves. None of these look familiar. Eugene. Who are these? List of employees for Walt Morris, Headmeister, Nicholas. I don't recognize any of his names. Sylvester, Rio, maybe these are the USVI. It's a mixture of male and female. So maybe those are the USVI employees. Could potentially be. Well, that is the first 5 of the first DOJ that they provided us with the DOJ. Okay, let's see what else is next. Okay, now we're back to data set 1. Okay, so that's 63 images. All right, open. I should say, oh, it didn't ask me if I was over 18 this time. Open. Do we have to verify still? Doesn't look like anymore. They took it for yeses. They believed us. Okay. Share this tab instead. Again, another image of that small office in Little St. James. More small office pictures in Little St. James. More small office pictures in Little St. James. Yep. 2 computers. Again, seems to be just different views of the exact same little office. Maybe this portion was it. Oh, this is the deed on the wall. So yeah, the first one was telling us what they thought. So I didn't see. It's a good thing that I went backwards, because then we wouldn't know what we found. So the last one was everything that we're going to look now. So they have the little offices. This is the photograph of the deed on the wall that was put in the notes. Sorry, I got excited. So I didn't share this out. This is the deed on the wall. And the first image that we saw that they put in that itemized list thingy, index, whatever. And oh my goodness. Thank you. Okay, let me get a hold of my attention span. Okay, so this is the deed in the wall that we saw with the first ones. I hope you saw this one too. Share this tab instead. Perfect. This, again, is just a small office. We saw the deed on the wall. Okay, I don't think it's me anymore. Every time I switch, it disappears. It disappears. Let me see what's going on with this. Give me 1 second. I think we're having technical difficulties a little bit here, guys. So this is the second batch that we're looking at. Just another image, office, office. I should have done this before. Office image, deed on the wall, as we saw in the itemized index, whatever list that we first opened. And this, again, it looks like images of the exact same office. So let's just exit out of that really quickly and go on and see what else the DOJ released for us in images and files. That's so funny that, like, I haven't seen anything about the Ghislaine Maxwell stuff, at least not yet. All I've heard from the news and everything they reported so far is pictures, videos, dancing, silly things, and the fact that Ghislaine's supposed to debug. I wonder if they're waiting for her to take the deposition before they report on the filings of her cases, or I bet you they're not going to say nothing, but we'll see. We shall see in the end. Okay, again, the same freaking office. Another one, this is just, like, literally, it's like a little garage, just tools, nothing interesting to see here. This is from the DOJ again. Serial number. Remember, we had serial numbers was written on the index. It looks like a computer serial number, more computer serial numbers. So at least we know, basically, we know what these are gonna be. More of the same office, little office, little office. And garage with ATVs. This is, remember, guys, we're looking at Little St. James, and this is where the DOJ released the Epstein files, while the House Oversight committees seem to have released actual documents. The DOJ is giving us lots of fun stuff in the form of pictures of Epstein's Island. Okay. More pictures of the garage and the ATVs. More ATVs. Remember how I just came up to me, they talk about in the Netflix Filthy Rich documentary, and in the Epstein, one of the USVI, that was great, yes, Epstein Jane Doe versus the USVI government. One of the girls says how she tried to run and they searched for her. And that just popped in because I see like the muddy ATVs, wondering if that's what they use to look for like the girls and victims, and they'll try to escape the island. And they'll send search parties to find them and bring them back. This picture, again, just a garage. Looks like they're trying to do some kind of, that's blurry, renovations. Are these even from the investigation, or are these seized after of him doing renovations? Because remember, in when Alberto tried to quit, in the letter we read, in the I think it was just the one that we just finished the police case now, to was saying you can't leave because we still have the project in the island. Wonder if this is the project that he was talking about. Because those pictures were from 2015. So again, it's between his final indictment and now. I'm trying not to miss them. It doesn't look like we're going to miss much, even if we don't open every single one. I guess we'll start from the bottom because that was interesting. I want to see what those images were. Okay. Of course. Same tiny little office, or another little office. Okay, Jeffrey Epstein, principal LSG employee. Oh, so this is one of his LSJE head pilot, as Larry I told you. So remember, if you've been following us, you would remember, maybe, potentially, when there was message pass notes from Larry Viscosi, and I let you know that Larry Viscosi was his pilot who took over Rogers. Larry Viscosi was his pilot towards the end, up to like 2019 indictment. And I showed you the picture, like the little, like fuzzy, frilly, weird looking hair. He was also awarded, I guess, for his loyalty, was awarded with multiple, like he was part of the board in a bunch of like shell corporations in the USVI, which they got sued for. All those cases I have documented in the USVI financial playlist that talks about like Gestali, JP Morgan, and all that. It is in one playlist, and if you go watch that, you'll be able to follow up with all the different like LLCs and how they were. Then eventually they got sued by the USVI. Convoluted story. Okay, anyway, go on. Administration of Southern Trust Company. Southern Trust Company is in that video that I did as well. HBRK, I don't remember. Darren Indicate told you. Darren Indicate, Richard Kahn, both were attorneys, part of the estate. They even stole money for the estate. Truly go and watch that video and totally catch up with what's happening with all of this scandal of USVI. And it makes sense that the DOJ would release the USVI cases because it's to deal with Virgin Islands and not them and not their people. So it looks like more people about like principal just LLC, like more fake documents for shell corporations, basically. Little St. James Island staff manual. Actually, one of the documents even has a Mar-a-Lago, like one of the files that I got access to, like part of the discovery. I believe it was for Ghislaine Maxwell's case, was a Mar-a-Lago staff manual as well. And then, that also reminds me, remember, Alessi in his interview, he said Epstein had taken everybody to the USVI to learn how to clean his house properly or whatever. This looks like another computer with serial numbers, small office, another small office. As it looks more of the office, more of this. Oh, I also just remembered in the USVI, Jane Doe versus the government of USVI, in that we saw that Jeffrey Epstein and the First Lady, Cecile Dijon, had offices right next to each other on the island, and yes, actually assaulted one of the minors in one of those offices while she was in there. I wonder if these pictures depict that office that they shared. Apparently, they shared like a wall, and it was a connected, like entryway, connected offices they shared together. That's Epstein and the governor's wife, the First Lady. And in that video, we also exposed the fact that Epstein paid for their kids' private school attendance. And he also got to help them write this offender legislation for the USVI. Watch that video. It's insane. Like, literally, this is okay. Next data set. We're going to look at what the DOJ has for us here with all the different data sets as fast as I can. I'm going to also like try and speed this up for the final cut. Hopefully we'll see how it goes so you guys don't have to go through it. Looks like it's just pictures. Okay, so this is emergency contact. Oh, this is more for one of his other corporations. Company LSG. I think that was to do with like the plane of flying. Another corporation documentation, incorporation documentation, incorporation documentation, incorporation documentation, incorporation documentation, incorporation. So that's all the same thing with the freaking DOJ. Okay, is this what they're showing Trump? No, he says there's nothing that is important in there. Okay, I would keep going. We keep going. Let's see how many I can truly open so we can get through this fast, quick, and painless. Nope, don't need that. SLG. See, this is what I told you guys about the first freaking document, Dom. They sent like multiple copies of stuff to fill it out. They keep pumping up the numbers. It's like millions and trillions. And I believe they keep saying like these millions and billions and trillions of files and evidence to rile the public up. But a lot of it, when they release it, is like this. It's the same photocopied item, like the same thing photocopied multiple times. That was just a desk. Sorry, it looked like it was just a desk that we missed quickly. Another desk. This could be the USVI office that he shared with the First Lady, Cecile Dijon. Where one of the girls a minor got assaulted with her in the office right next door. The only reason I say that is A, the description. If you watch the video, you'll know. And B, because it looks fancier than that little like closet thing we're just looking at. So it looks like another office for Epstein, another office. Maybe this is actually on the property. I don't know. Utility. They have a bunker. Utility bunker. They have a bunker at Epstein Island. There's a bunker. We should go look into the bunker. I wonder what's in the bunker. I don't think it's just utilities. What is that? That's the bunker. Okay, so if you go on Little St. James and you're looking for the bunker, look for where the American flag is positioned on the island. There is, right there. There's the bunker. Epstein's bunker, I believe. Or what if the DOJ like put another secret bunker that we're supposed to know of? So bunker images, 7, 8, So now we're going inside the bunker, people. Now we're going inside the bunker, okay? So it's just a utility bunker. So far it looks empty. What is that? That looks like a projector. Do they watch movies and stuff? That looks like a projector to me, honestly, inside this utility bunker. It's on a hill that has a United States United States flag positioned on top of it if anyone's looking for the Epstein bunker. As filed with the DOJ. Filed and note. This is what I thought the whole thing was gonna go and be through, just going through just pictures. I did take a sneak peek at the DOJ, and I didn't look at the House Oversight Committee. I honestly just thought it was the exact same thing, just one was kept online and the other gave you access to a Google Drive. But it looks like the two different departments are releasing different documents. Let's see. What do we have here? We're still in the bunker. Looks pretty empty. So this could have been pergola and storage area. I'm thinking that's what that says. So let's see pictures of the pergola and storage. I'm right. It is a bunker on Epstein Island. Oh my God, these freaking idiots. Now we know the full layout of Epstein Island. Okay, so we know for sure there's a bunker. Is this the pergola? So this is a pergola going up. So now we know they're building, like the land property markup and layout. So this is still the bunker, it looks like, on Epstein Island. So maybe that was a projector. You never know what those like creepy people are doing inside that bunker. Now we go to Grotto. Okay, Grotto. So I think this is actually like Epstein, like construction renovation island files and stuff that we're looking at right now, because this is not completed. So this is the construction construction images when they're building Epstein Island. We get to see it all. So this is the grotto. We've seen pictures of Ghislaine in the grotto as well. Let me see if I can find that for you. Images. Ghislaine Epstein. Images. I had someone tell me that they did not know how to use Google. I was flabbergasted. I'm like, how do you not know how to Google? You type what you want and it gives it to you. That's the same thing with AI. Why do you need to learn AI? You type it in. Don't you know how to ask? There we go. There's the gross grotto pictures. So this is before it went in. Look at that. Bill Clinton. Do you think they're going to ask him about swimming in the grotto? There we go. Clinton pictured in pool. There it is. There it is. And where's the building for it? There it is. So before. This was the before, the grotto that they're swimming in, all the terrible things that must have happened in there. Ooh, oh my God, yes, the sundials. So we're even going to see the construction. Sorry, I just started. I want to delete some of the pages as we go, so I don't have to come back and do it later. So so now we're going into the building of the sundial. Here it is on the island. I was just like, I'm trying to intentionally, I'm trying to intentionally not look at other coverage to like kind of like not skew me. And I need a break. Like when I'm not doing it, I don't want to be into it. Like it's a lot of dark, heavy content and topic. And I ended up falling on Femme Tarot. And she was talking about like how, I don't know, she was saying something about children and how dark it is. But I see just looking at like the sundial and the whole temple and everything, there's something really creepy and ritualistic about everything that was happening on that freaking island. Anyway, I digress. We keep going to the older one. What I want us to do, what I think we should do instead, to kind of like foster community, do this as a group. We need a community that is strong enough to stay involved in this thing. Because without it, I trust. They are only going to keep talking about the Epstein case and the Epstein files as long as they get the clicks and views and the like whatever funding they can get to it. Once it starts to look like it's no longer beneficial for them, they're going to stop reporting. And while they're reporting, they're only going to report what they're allowed to report by the people who control their purse strings and their jobs and their contracts. So it's going to be up to a community of people. Like people actually care to make sure these files get out. Because trust me, they're hoping we all have such small attention spans that we forget about what happened in the Epstein case. That's all Trump has been saying to us. Why doesn't everybody forget it? I'm really, really determined. I'm motivated to get everything out. I said it before and I'll say it again. Like, what is really driving me was the Billionaires Playboy Club reading by Virginia Roberts. And I think it's such BS that she was called a liar and how everything transpired in her life. And I don't want it to be for nothing. I really don't think it's fair for her death to be for nothing. And she may not have been able to do it. And I don't know if other people are even that willing or interested to get the full truth out. But when I read the Billionaires Playboy Club, among the court case and files, I was determined to get the entire freaking truth out. And I might be stumbling, but I am going to get it all out. And I need your help, the audience. Those people actually care to know the true facts. Those people who want it out to know the facts. That's who I am calling out. This is a call to action. This is a grassroots project that we're doing together. Bare bottom. Bare bottom, but the only thing that I can give you is integrity and a promise that this information is going to be put out with the utmost respect that I can. So make sure to hit that subscribe button if you are interested in knowing all the Epstein files, what I want us to do. So I'm going to put a poll at the end of this, and it's going to break down all of these papers. Get together. Let's start building this community. Let's start the discourse and start talking about this and getting this information and facts out. Open discussion. So whatever you guys decide to choose, vote for, gets the most votes for what we should look at, I'll just pop that file open and we'll look at everything in there for next Sunday. But Monday, Wednesday, Friday, we are going to be continuing on with reading the police case notes. We're almost done that, and then we'll pivot directly into the grand jury testimony and transcripts. Put together an NPA and bail and financial. So that's like background information of Ghislaine Maxwell. And this count, it's just going over the different counts and the indictment. I asked, like I said, Choji asked Gemini to kind of go through and let me know what was in the folder images 001. Here we go. I don't want to show everything, because I feel like there's a very huge problem with accountability and transparency with this whole case. I want you guys to see what I'm looking at. Know that I am not pulling any fast ones on you as we look at. Now, the other thing that I wanted to quickly look at. So I hadn't gone through. So I thought everything was just going to be go images and videos, like has been reported all weekend from like all the major news and podcasts and crime, whatever. It's just been like, I've seen videos of like Epson dancing and images in the islands with like black like spots, and that I thought that's what we're looking through. But then it looks like the House Oversight Committee actually released documents. Now then we pivot to the DOJ release. It looks like they're not working together. They're working separately. Let's look at what the DOJ released here. So DOJ released separate Epstein Files Transparency Act, I don't know what that is, as well as a memorandum correspondence. So it looks like the DOJ and the House Oversight Committee are releasing two different things. There is 64 pages here of information. When I was going through it, a lot of it was, it all appears like this is from the USVI cases. Again, there is a full playlist where I look at the different civil suits as well as the cases brought against the USVI and its government by Epstein's victims. And the USVI Attorney's Office also. It talks about Plaskett, the Democratic senator who received, I believe, off memory, it's been a while since I did this video, about 30,000 or 70,000 for her campaign. I'm going to say 30,000 for her campaign. From Epstein, it also reveals how he was paying for the First Lady of USVI. So for all those who are like, First Lady what? In USVI, the governor's wife is called the First Lady. So he was paying for the governor and her kids' private school tuition. That's in the Jane Doe versus the government of USVI video. We also, in that video, we learn a little bit about the Epstein estate as well with Richard Kahn. There was images there as well. I'm just showing there are 64 pages of images. All these images, let me start with this. This is a goodie. All of them seem to be of USVI. So it's literally this stuff. There's like multiples of a tiny little office, description of photographic subjects, There's multiples of a tiny office. There's a deed on the wall. There's like just images and pictures that they had. And then there's also what looks like construction of the island itself, like construction of the grotto. For some of us, we might remember the grotto was, we'll look at those images next time. The grotto was of like pick images with, actually no, let's do that right now. Ghislaine Maxwell and Clinton swimming. See, I had looked for it. I wasn't fibbing. I looked for it and then we talked about it and then it didn't record. It said no. The temple demon said no. So we saw the grotto images, but Bill Clinton pictured here with Ghislaine. So we saw that like before they're building it up. There was also an Android. We are going to look at everything. So this is what I'm going to do for us. Since this drop just happened, these last files just happened. We've all seen the sensational pictures and everything is out there. I will go through everything and anything that's like fun. There's nothing fun about this. Yeah, anything that is seen as important for everybody to see in respect to the pictures or emails or anything like that, we're going to review it next week. Could be before Sunday, actually. I just need time because I'm going back and forth between going through the police notes and then reviewing these new document dumps and images as well. So during the week, I'll let you know for the community post when when we can go through all like the different images and pictures from the DOJ. Looks like the House Committee released files while the DOJ released, images. I haven't seen all of them, but so far it's just pictures of Epstein Island and nothing really incriminating. For salacious, I'm pretty sure the salacious stuff I've already seen by now on BBC, CBC, and wherever else we'll look, but I'll still look through it. Let's take a beat right here. For now, I try not to there's so much in here. I think we're going to be talking about this for like, I don't know, the rest of my life. I don't know how, like, there's so much to go through. There's so much to talk about with this whole case. There's so much to review, but I am determined to get the entire freaking truth out. Like I said before, when I read the Billionaires Playboy Club and Virginia's story, this is the version that was never released. This is the version that she had been working on by herself that was submitted in court documents and therefore suppressed and like what you'll eventually see if they ever release that. It'll be heavily redacted, but I have the unredacted versions. I just like I could hear her pain and I think it's absolute BS the way she went out. And the fact that she died with people still thinking that people would never believe her, would never believe her story. And I am just, more than anything, I'm motivated to do this for Virginia. That's the truth. I want to if she couldn't do it when she was alive because she fought so hard, I want to complete this journey and this mission for Virginia. And he was just another asshole who saw a vulnerable woman, a vulnerable girl. And you know what? Actually, let me just say this before we wrap it up here. I remember when I was reading the Billionaires Playboy Club, before it came out about the abuse that she was going through with Robbie in her marriage the entire time before she took her own life, I remember reading it at the end, and something at the end when she details how they met in, I guess, in Thailand, and they got married really, really fast. And it's because she told him, the husband, Jeffrey. She told Jeffrey about her traumas, and he said that he wanted to save her from it and marry her and sweep her away and like to Australia. That's, first of all, isolation. I was praying when I was reading that, I hoped that she would have found like her happy ending at the end. And unfortunately, now we all know that she didn't. But there's something that should be questioned twice about a man who is so eager to step into that role for someone who's coming out of abuse. But in the way he did it was so controlled. Like he married her right away. He wanted to marry her, put the ring on her, like kind of like whisk her. It's so controlling and whisk her away. Because they're predators. Abusers are predators, whether it's sexual, whether it's physical. They are predators. Her husband, when he met poor Virginia in Thailand, thinking she was trying to escape, he saw the perfect victim because of her history, because of the trauma and what she was going through and not being that close with the family. He knew she was the perfect person that he could freaking take and isolate in Australia on an island and beat and treat miserably and further abuse. For all those women out there and all the victims, not just women, anybody out there who's been abused and you find yourself constantly in that same cycle, I want to tell you it's not your fault. These people are predators. Like a lion, I don't want to say a lion. Lion is a fierce beast, but just like a lion hunts his prey, these kind of men, these abusers, these men, these women, these beasts are looking for prey. When they see your trauma, you may be looking for someone to understand. A lot of the time, we hope you find someone who can shelter you and understand and help you heal. But a lot of the time, they will attach to you because they see that trauma as a weakness and as their way, as a nut. They see you. They see you coming from a mile away. When you find yourself in the same abuse cycle over and over again, I know it's easy for you to start blaming yourself. Like, is it just me? Maybe I deserve this. I brought this on myself. These people are predators. They're hunting you. They know your trauma. They know how to talk to your trauma. They know how to soothe your trauma. They know how to make you feel like they are the answer, only to make you their victim afterwards. I would say the advice that I'll give, the best way is to heal. Like, you need to find way easier said than done. But the safest route is to find the healing and that strength and that, resolve within. We have been brought up and we've been taught and we've been raised so much to look externally. Look externally for help, for like the outside validation and outside like understanding and outside acceptance. But for a lot of it, we need to look inside because at the deep core, we have the answers that we need to help heal. And until that strength comes from within, it will never be stable. And it's not, again, not victim blaming, but it's what those predators are looking for. They are looking for someone who's not strong enough on their own to be able to take out that third leg and take you out. They're looking for someone who's standing on three legs, still healing from trauma, still in trauma to take that third leg out. And they always come in as a knight in shining armor, as the answers to your dreams. Again, in the Epstein in the USVI video with the one Jane Doe, it was revealed in the USVI investigations that Epstein and his like cronies or co-conspirators would go to New York, Chicago, different places, and present themselves as philanthropists, go to families with minor troubled youth, like around the teenage, like 13, 14, 17, 18, whatever, promise them the world. Some of them don't even say, we will help you pay your rent, give us your daughters. Same thing they did when they went to Eastern Europe to find the young girls and bring them back. Eastern European girls was, let us help you. They look for people who are already on three legs, who are going through trauma, who are not safe. They come in to pretend they're going to be a savior so they can re-victimize you. It is so hard. We need these conversations going. And who knows, maybe if we keep putting these spots on the internet where victims or people can say the truth without getting scared about defamation and like cease and desist and getting sued. Come sue me. I have nothing. Come sue me. I don't care. I'm going to say everything out loud. It can't be defamation if I'm reading the court documents, can it? No, I don't care. I'm going to get it out. And hopefully by continuously doing this little uphill, this little voice until it gets louder and louder. The only way we can really figure out how to get justice and support the victims is if this tiny little voice gets louder and louder and louder with all your help and all your support. I went on a rant again. I keep saying again, I have ADHD. I do tend to ramble sometimes, but let's leave that here. Again, thank you all for your support. Let's join together. If you've watched it, if you've watched up to this late, you are part of the team. Let's stay committed to get this files out. Let's share it. Let's talk about it. Subscribe. Help me. Also, in the comments, let me know any other ways you think that I should or shouldn't do to get this message and these details and these stories out. Let me know. I have one goal and one goal only, and that is to get the entire Epstein investigation and facts out. See you next time.